Well, good morning, everybody. Welcome back to the ROS Media channel. And today we are going to be going through our weekly webinar Q&A for last Saturday, which was 16th of May. We've taken on board your feedback and your registration questions from the 16th. And it's clear that there's a deep need for more understanding, I think, regarding the mechanics, regarding IRS correspondence, and also how the protocols themselves can be sort of practically applied in a day-to-day life situation. So today, hopefully, we are going to clear the fog on all of that, address your questions directly, and just help you to establish this roadmap that your household needs to maintain total control of this monopoly board. So, Ian, great to have you on. Let's get into the questions. The first category we've got today is really to do with just more structural side of things, the strategy and the pivot on the mortgage side of things, going into the New York courts. We've had a number of questions regarding that. And the first one is the Mortgage Liberation Protocol seems to have shifted from a process of peacefully recouping the value of the mortgage to filing a strategic court case in New York using AI-drawn legal frameworks. For members who explicitly entered the protocol to secure a peaceful settlement without direct confrontation with the system, what is the mechanical reality of this shift? And can a direct settlement still be executed?
Well, it's a great question, and it shows that the gap between what we're doing and what people are understanding that we're doing. There's a bit of a gulf there. Some months ago, I presented the peaceful exit, and that hasn't changed. So for the overwhelming majority of the members who are not facing a mortgage foreclosure or extreme hardship because they can't fund the mortgage installments, the peaceful exit is absolutely the way that I would go if I was in that situation, because quite frankly, going to war with banks is a stressful endeavor. It doesn't matter, whether you're right or wrong. It's a war, and having fought many of them in my time, they can take over your life. Literally, they take over your thoughts, they take over your actions, they take over your mood, because the banks don't go away without a fight, and they employ the most heavyweight law firms you can imagine, because they are protecting a system, and they're protecting the slavery system. That doesn't mean that you can't beat them, but they're not gonna surrender easily. They're not going to want to be seen to be beaten on anything, which is why you rarely see banks lose. So the AI system, which we will introduce in the near future, is really for people that want to take on the banks, because they wouldn't be just taking on one bank if it's mortgage related. They'll be taking on the alleged mortgage provider, the bank that they think lent them money, or they held themselves out as if they lent money, which of course we now know that banks don't lend their own money. And then they'll be taking on the indentured trustee, which is where the top of the ledger is. The indentured trustee, which is the investment bank that's holding the mortgage note, the mortgage security, and crucially, paying taxes for the use of the signature credit energy to the United States Treasury, which kind of proves that they are nothing other than a nominee, and they are not creditors at all. Because if they were creditors, they wouldn't be paying taxes for the use of the signature credit. If it was theirs, they wouldn't be paying taxes on it.
No.
So that is the big Achilles heel of the entire mortgage market. I've just finished this morning writing another paper on what New York lawyers are likely to say about the top of the ledger discharge of a mortgage, which is for those who don't know what it is, you create an international grantor trust. That grantor trust sits on the monopoly board as potentially as a creditor. It's not a creditor until it files 1099 OID. So off the board is the living man, woman. The living soul can't step on the monopoly board. The grantor trust, foreign grantor trust, files 1099 OID and then becomes a nominee for the living man, woman who's off the board, and crucially secures what's called holder in due course status or standing. That holder in due course, which is perfectly in line with the IRS publication 1212, whoever is the holder in due course is the creditor. So the creditor is presumed to be the investment bank that's holding the note at the top of the ledger. They hold themselves out as if they are until the grantor trust, the foreign grantor trust, files 1099 OID, which then changes the ledger. It's perfectly in accordance with IRS publication 1212. So now the investment bank can't say that they are the creditor anymore. They can't hold themselves out as the creditor without a lot of problems for them, perjury and all kinds of stuff. So that's when the game changes. But what you've got to do is you've got to get to that point where you've got that structure in place and you've got a case in New York that where all the evidence, and it needs forensic evidence. You can't just say these things.
No.
You've got to actually prove them all. So you've got to prove that the grantor trust has filed 1099 OID and it's been accepted by the IRS, that you've got a IRFM 26-digit reference number. You've got to prove that the investment bank is actually holding the note, because their standard defense is, well, we don't know anything about this mortgage note. We don't know anything about it. Yeah, jog on down the road and have a go at another investment bank because we can't recognize this mortgage, because they're not used to people finding the mortgage note within their securitization structures. So you've got to do all that research, and that's of course what the AI system can do. It can find the note, it can track it to the investment bank, and it can locate the all of the linkages between the mortgage provider, which is the servicer, because they actually become a servicing agent for the investment bank, because they're collecting installments for the investment bank that is purchased the note from them. So the racket sort of unfolds when you can trace it all through, which the AI system can do. But then you've got to get a positive decision in New York, which I'm not going to say that's going to be easy, because it probably won't be. The lawyers in New York, they're probably the most highly paid lawyers in the world. Why? Because all the banks, the big banks, are in New York. So the toughest opponents are going to be New York law firms. I've been up against one before, and they are tough. All the Ivy Leaguers go to New York, the Harvards and the MITs and the Princetons and all that lot. Where do they end up working? In New York. Because the biggest payers are the investment banks, who pay lots of money to get representation. So this isn't an easy task. If anybody thinks beating banks in courtrooms is easy, they've never tried doing it. But all of the evidence is in the research. Really, it's in the research of the whether the bank that calls itself the mortgage provider actually created any loan. Did they actually loan their own money, or did they create it ex nihilo? Well, that's easy to prove. Then you've got, did they sell the mortgage security to the investment bank? Well, that's easy to prove if you've got the AI research capability. then is the investment bank paying taxes to use that signature credit? And that's where the research on the investment bank's 945 tax module comes in. Very few people know about that tax module, so it's an interesting one. It's going to be very interesting to see how that plays out, because you can't deny it. Investment bank will have a hell of a job denying their 945 module, because it's in the public domain within all the SEC returns. So they can't say it doesn't exist, because you can prove it does. And then you've got the 1099 OID and the IRS publication 1212. There's a bunch of other things as well. So for the bank to win in New York, it's going to be tough for them, because normally what they normally will argue is three things. They will argue that 1099 OID is fraud, and that's because most people file 1099 OID as the debtor.
Yes.
And don't know about the international grantor or foreign grantor trust. Then they will argue that the case is ridiculous, because their role as an indentured trustee is to look after their investors. Their duty of care is to their investors, not to mortgage holders. They will argue that one, because that's what their job actually is they're there to protect the investors in their bond structures. So they will argue that their trustee obligation is to the investors, not to mortgage holders. But there's a critical and fatal flaw in that argument, which is that would be okay if they still were the creditor of the mortgage. But they're not, because the mortgage has been discharged by the 1099 OID filing. So they can't argue that, hey, you know, we're only looking after our investors. So again, you've got no case against us, because we've got no obligation. It's called duty of care to you, mortgage holder. Well, they have if they've been reporting that they're the creditor, and that's now changed, and they've sent in their returns every year, which they do under the Indentured Trustee Act, that they are creditors when it's been proven that they're not. So now we're talking about fraud. We're now talking about trust fraud. We're not talking about duty of care to their investors. We've shifted the landscape. We've shifted the argument to fraud. And then the next thing they're going to argue is that in New York, what's called pro se litigant, which is a living man or woman, can't represent a trust, because it's the trust that's taking them to court. It's the grantor trust that's taking them to court, and they'll say, you need a lawyer, because you can't, a lay person can't represent a trust in a New York courtroom. So strike your case out and let's all go away. Well, they're not going to win that one either, because the beneficiary of the trust is the living man woman, who's also operating as, get this, the general executor over the decedent estate, which is why you need the envoy protocol. One of the reasons. And now you've got standing in the court because you are a beneficiary of the trust. And there is law in US law that says that if you are the beneficiary of a trust, you can take on the case as pro se litigant, because you're being directly affected by the trust. The trust's case basically is your case. So the bank will argue you can't do it, but the law says you can do it. And we already have had one case accepted on that basis, where the lawyers said you can't. It's in MC's case. You can't come here with this because you're not a lawyer. Well, that was batted back, and the judge accepted it. So accepted that you could go there. It's going to be an interesting thing, but again, the question is about signature credit recoupment, and the peaceful exit is the preferred route, because you don't want stress unless you've got no choice. The AI system and the avatar system that we will develop and roll out is for people that haven't really got a lot of choice. They're up against it. You know, they haven't got the luxury of, well, you know, let's wait for 6 to 9 months for our signature credit recoupment to come in, and then we'll discharge the mortgage and then recoup the discharge. They haven't got that luxury. They're up against it. Maybe they've got bailiffs knocking their door. Maybe they've got mortgage arrears, and maybe that's stressing them out. So it's horses for courses. It's different scenarios, and the AI system will be, you know, I think attractive for those people that are up against it. I mean, some other people that don't mind a war might be attracted to it as well.
Possibly, yeah.
Some people quite enjoy the fact that they might be able to beat the banks. I'm not going to say who's right and wrong here. It's up to the individual. But having fought banks before, it's a full-time job, guys. So just be aware of that. Even though you might have an avatar and an AI system, you'll be doing something on your case nearly every day until it concludes. And sometimes you'll be doing lots of stuff on a day. The whole day goes putting your case together and sending it off and responding to this, that, and the other that comes in. You're in a 5-set tennis match against Roger Federer, so you've got to be good on your game. If you compare it to a tennis match, you're walking into a 5-set tennis match.
Okay. So next question is regarding retroactive legislation. And the question is there any risk that a future government, court system, or international monetary body could implement retroactive legislation to completely reverse or void the asset titles and recoupments achieved through these protocols?
Anything's possible. You know, there might be a nuclear war in the next 2 seconds. Who knows? Anything can happen in this world. Can governments bring legislation in and retrospectively apply them? In the law, no. Can they do it? Yeah, they can do what they want. Is it likely to happen? It's more about probabilities than it is about whether they can or can't do it.
Yeah.
Any government can do anything it wants. Why? And that, you know, if you let's get into why, right? Every citizen that is the birth certificate construct is registered to the state. They own it. So if you had a flock of sheep in your field and you wanted to move them from one corner of the field to another corner of the field, guess what? You could do it, couldn't you? Because you own the sheep if you were the farmer. So that's the reality of it, is the farmer can move the sheep around whenever he wants.
Yeah.
And that's the reality of this monopoly board, right? And that's why people don't normally win when they go up against those that control the system. The governments are running an agenda knowing that they've already got control of the slaves because of the registration of the birth certificate, because of the agency between the living man and the living man woman in the birth certificate construct. The slave chains are on from the birth certificate moment forward. You know, what you're going to do, you can cut the chains, or you try to cut them, but that's very difficult. You can defend individual actions that might be, you know, coming along by becoming the general executor of the decedent estate and repositioning your standing, but you can't take away the agency. It's there.
No.
You know, it's that's the big problem. So can the government change legislation? Yeah. What's the probability of it happening? I think very low probability, because the whole monetary system is based on ex nihilo credit creation. It's based on the model that's been running since 1914, really, with the Federal Reserve Act, when it came fully into force. Are they going to change that? The implications are huge. That if they change legislation that stopped the banks using signature credit energy, it would be a massive U-turn.
Yeah.
Worldwide. Would they do it? I don't think so. Could they tighten down on the amount of signature credit that you can draw out of the system, the redirection of the taxes, which, you know, in my more recent research, there will be a review if you recoup more than $2 million a year.
Yeah.
There's going to be a review on that filing, right? So they could bring that down. They could make it $1 million. They could make it a lower number. And then if any signature credit recoupment over that, whatever that threshold is, would go into the review. But then that's counterproductive for them as well, because every review can be fought, because the law is clear that the signature credit recoupment fits the law, and it's all in my research papers. I step it all out, all the law that supports this. So if they deny the signature credit recoupment, then you can go to appeal. You can go into a procedure where you're actually fighting the United States Treasury. And I'll explain why. The United States Treasury is the bankruptcy trustee for the creditors. So if you turn up as a creditor, which you are turning up through the grantor trust as a creditor, and they're denying you your signature credit recoupment, you now have every right to take them on, because they're not doing their job.
Yeah.
They're the bankruptcy trustee for you, the creditor. So you would take them on as the living man, woman through the grantor trust, same way as taking on the banks in New York on mortgages. You would take them on there. And there is a procedure to take them on. And I don't want to go down that pathway, by the way.
No.
So I want to avoid taking the federal government on thousands of grantor trusts. I just don't want to
do that.
I don't want to go there, really, because that will engulf us. So no, I mean, the thing is, they can do anything they want. Is there a high risk of it? I don't think so.
No.
If they think it's actually changing their slavery model, then they might want to change something. But I don't think at the level we're doing it. If you think of how many billions of taxpayers there are in the world, citizens, debtors, what are we talking about? We're talking about a tiny, tiny percentage of them.
It's a drop in the ocean.
It's a drop in the ocean. I mean, why would they change the whole system to stop a drop in the ocean from, changing the ocean? It's not going to change the ocean, is it? The ocean's going to stay exactly the way it already is. We can't, this is what I've been saying. Not everybody in the world can do this. And that's their protection, right? Because and that's actually our strength. It's one of our strengths. Because if everybody in the world could do this and we could enable it, then they'd have to change their entire system. But because not everybody in the world can do it, because it's constrained by the level of taxes that the investment banks are paying, that means that the threat to their slavery model is very low, if anything at all. Which is the strength for us. You've got to really think about these things. When you get into them, you've got to think about the game, right? You've got to think about the two players in this game. And the big player is going to say, does this really matter to us? And they're going to conclude, not really. So we just let them carry on, shall we? Why not? Why do you think they let certain criminals carry on? Why do you think they don't go after, everything, all the criminals? Because they can't do it. And it's only a tiny amount of the problem, yeah? So they let things go that don't threaten their control model, from my analysis. If you're going to threaten their control model, then they'll probably try and stop you. But I don't think we're ever going to be big enough to do that.
No, I agree. The next question, Ian, is to do with allodial title versus fee simple. And the question is, to achieve absolute ownership of a property upon clearing a mortgage, should we be demanding the allodial title rather than the standard fee simple title? For international jurisdictions like Australia, where the state claims only fee simple is obtainable, what's the administrative workaround to break state residency ties?
Yeah, I actually wrote a whole paper on this about 2 months ago. It's a tough one, right? Because the whole Monopoly board is under usufruct. So the entire Monopoly board has been mortgaged to the original creditors, the banks, the big families, the 13 families that many people know about, the Rockefellers, the Rothschilds, the Astors, the Warburgs, the list goes on. They have basically taken out a charge over all of the assets of the entire trust, which is the World Monopoly Board. They hold the legal title. That's the truth of it, right? Unless there's churches involved. Yeah. See, the churches retained ownership of land because church land was sacred. So there are some exceptions. There are some in the United States system. There is some land that you can go back to Lincoln actually, and there are I can't remember what they call it now, parchment, something. It's in my research. Basically, there were agreements going all the way back to President Lincoln's day, where people could own the land, and there were documents that were structured and signed off, hundreds of years ago when Lincoln was around, that your family could own the land, like the church could own the land, the legal title of the land. So when you unpack this, in reality, nobody can own the land. Not really, not even the creditors, because the land, I'm not getting religious, but the land is owned by God in the system.
Yeah.
Because the whole legal system is based on the Bible. And in Genesis, it's like God created the world, yeah?
Yeah. Yeah.
So he who creates owns, yeah? That's a maxim of law, right? So you go all the way back to who owns the land, and and I'm not religious, but according to the Bible, God owns the land because he created the earth, according to the Bible, which is what the law books are all pretty much based on. So nobody can actually own the land in their system apart from God, if there is a God. And I don't want to go down this pathway because it's too many rabbit holes, but
I understand. Yeah.
What I know is that the law is based on the Bible, that's what the Bible says. So what you want to achieve, in my opinion, having a load of your title, the actual ownership of the land, which really isn't owned by you anyway, because it's in the Bible, it's owned by God, it's a nice thing to have, but what does it actually give you? What you want is control. And you can get control with fee simple. And you can stop taxes being levied on the land with fee simple. You can shift the equitable title in, which is you've got a allodial, fee simple, and equitable title. And you can shift if you can't get the fee simple, you can get the equitable title. And you can put that into international trust, and you can make it really difficult for any government to tax the equitable title of land because they don't have jurisdiction over a grant or trust.
No,
because a grant or trust is an international it's foreign to the United States, meaning it's international. It's like Switzerland saying, "Oh, we're going to tax the United Kingdom." Well, really? Well, under what jurisdiction are you going to do that, Switzerland?
Yeah, yeah.
It's not going to happen, is it? Unless there's a treaty. It ain't going to happen. So it's more difficult for them to tax a grant or trust, which is international, or to try and take things away. So it's really all about control. Trusts are used for control. That's why trust came about. If you look at the Sesquivet Act, 1666, that's really when trusts started being used. And when the Crusades were going on, you've got the use of trust. So people the knights would form a trust, and they put their land into trust. so that if they were killed in a crusade, their family could still stay on the land. That's really where trust comes from. It's about control, and the trust gets the control, whereas the settler might die, might have been killed in battle. That's where trust really came from, and that's what you can do here. You can put things into the trust, and whether you survive or not, it doesn't matter because the trust has the control. That's why trusts are very attractive. If you know how to set a trust up properly, not just a bit of paper that says it's a trust. It's got to be set up correctly. But fee simple, allodial title, I think there's a misunderstanding about what these things really are for the majority. And then there is always the question that I always ask is, what is the objective? What's the objective? Is it to have ownership and no control, or is it to have control and no ownership?
Well, we talk about that, don't we? We talk about control everything, own nothing.
Exactly, yeah.
Okay.
So yeah, the bottom line is everyone's renting, really. You're renting everything from the monopoly board. So do you have control of that asset so you don't have to pay the rent anymore? That's where you should get to, in my opinion. It's all about control.
Yeah.
Ownership is, I don't think ownership, when you really boil it down, is that important.
No, not if you have the beneficial use of. Ownership creates liability, doesn't it? To some extent.
Well, that's the other thing. Yeah. I mean, if you own something, you're liable for it. So is it not better to have control of it and use of it, but not having to pay tax to use it, rather than having control of it and ownership of it? Because if you have the ownership, then you've got the liability.
Yeah.
I think that the smartest people that use trusts are quite happy with control and no ownership.
Yeah, agreed. Okay, so next category is to do with
the
private treasury.
Anyone? 1 second.
Okay, just bear with us, guys.
Give me a minute. My speaker's dropped off for some strange reason. Just bear with me a minute. I'm going to have to connect a different speaker because this one has stopped working for some reason.
That's okay. Well, while Ian's doing that,
let's got another speaker.
Let's talk a little bit about this Saturday as well, because it's now Friday, the 22nd, and tomorrow we have another webinar coming.
Yeah, so it started working, didn't it?
That's not a problem. I was just saying that it's now Friday the 22nd, and we also have another webinar creeping up tomorrow on the 23rd, which Ian and I will be doing together. So we'll have a little chat about that towards the end of the Q&A session today. But yeah, the next section, Ian, is to do with sort of private treasury mechanics and some of these IRS anomalies that people have been experiencing as well. So one of the questions was to do with dual EINs. And I don't know whether this is a question we can answer or not. This, to me, sounds more like a tax filing type of question or a filing department type of question. But the question is, why is the IRS sending out two different EIN numbers for a single private trust in separate letters 2 weeks apart? How can a member verify which EIN is active and valid within the federal system? And what's the protocol if they continue to receive multiple numbers?
Well, normally what they make a lot of errors, the IRS actually. They make a lot of errors. It's unbelievable. Unless you've actually experienced it, because everything's being done manually. To get these grants or trusts is a manual process. It's not there's no database, electronic API type filing. It's not computer to computer. It's actually faxes and phone calls that create these trusts. And so that's what one of the functions of the office in Bali is, to get these trusts off the ground. And what happens is that the IRS makes mistakes, and they get names wrong, and they get addresses wrong, and then they send them out, and then our team generally looks and establishes that there's a mistake, and then reapplies. So that's probably why there's 2 coming out. So it's not the IRS sending 2 because there's some reason for them to do that. It's probably an administration error on the first one, and it's been corrected on the second one.
Yeah, that's what it sounds like to me. And, you know, we know it happens. It's happened to my wife. I think she's on her 3rd application for an EIN number because of 2 previous errors on the IRS's side of things. So it does happen. It's not uncommon. Okay. Form 945. When the total volume of an investment bank's paid tax filed on their Form 945 is fully exhausted, how will ongoing 1099 OID recoupment actions be affected for both existing pending claims and new members entering the pipeline?
Well, that's the best question I've had for a long time.
That's a good one, isn't it?
Yeah. So when you look at the investment banks, they've got different tax modules. I've written a research paper on this, quite detailed, and it's about understanding the 945 ledger. The 945 ledger is probably being funded at, I'd say, less than 1% of the true tax liability. What the banks are doing is they're putting the taxes onto other tax modules. The big one is the 1120 tax module. So what the grantor trust can do, and now we're going to get a bit deeper into the weeds here. So the grantor trust becomes the holder in due course because it's filed 1099 OID. The holder in due course is the creditor. Now, when you file Form 56 as the creditor to the IRS, you become, you don't become, the trust doesn't become the taxpayer, but it can control the taxpayer. So then you get into Revenue Procedure 2002-2026, and the grantor trust, or the officer for the grantor trust, can actually control the tax ledgers or tax modules of the payer, investment bank in this case, because they've taken over the entitlement of the taxes.
Yeah.
So you've basically corrected the record, and where the investment banks have been presuming that they are the creditors and no one's corrected the record, now the grantor trust has corrected the record. The taxes that they've paid now belong to the grantor trust and all the other grantor trusts that have filed 1099 OID. And the officer for the grantor trust or trusts can command the IRS to move the taxes from the 1120 modules and the other tax modules onto the 945, because they've got an absolute entitlement to it. And Form 56 gives them the opportunity to step into the shoes of the taxpayer and command the IRS to move the taxes from the other tax modules onto the 945 tax module. What you can't do is force Goldman Sachs to pay more taxes than they've already paid.
No,
you can't do that, but you can move the taxes from other tax modules to the 945 tax module
to make up the shortfall. And I think it's interesting that differential between acting on behalf of taxpayer or acting as the taxpayer. So it's a very powerful position that the grantor trust has, isn't it?
Yeah, you basically become.
You're not asking, you're telling, aren't you?
Well, it's very difficult to get your head around this, right? So you file, the grantor trust files Form 56 to the IRS, and basically is saying, we as this trust is a creditor, is the holder in due course, and the taxpayer is subservient to us, to this trust. This Form 56 gives the trust powers over the taxpayer. When I first put this into a research document, one of our guys internally called the IRS and came back and said, well, they won't tell me anything, Ian. You know, it's like, how can I ask them about the taxpayers' taxes, the investment bank's taxes? And I said, because you become the taxpayer when you call up.
Yeah.
Through the Form 56.
Yeah.
Well, you don't become the taxpayer, but you have the rights. You basically step into their shoe. You've got two positions. The grantor trust is the holder in due course. Form 56 then steps into the taxpayer as if you were the taxpayer. So you can command the IRS as if you were the taxpayer if you're calling. Obviously, members aren't calling the IRS, but the officer for the grantor trust calls the IRS, not as, please, sir, can you please tell me how much tax has Goldman Sachs or Morgan Stanley or any of the other investment banks paid? And the IRS is going to go, it's none of your business.
Yeah.
So you're not calling them as the grantor trust. You're calling them as an officer of the grantor trust with rights over the taxpayer. Form 56.
Yep. Okay. So next question is day-to-day trust banking. Once our Asset Fortress Trust Bank accounts are finalized, how do we operate them on a day-to-day basis? Is there a set limit to the client cards issued? And can we open automated sub-accounts directly within the private banking institution?
The bank account that is linked to and connected to the Asset Fortress protocol is like any bank account. It's like any trust bank account. If you want to have more than one of them, like you can have more than one account for the birth certificate construct. The citizen banking. If you want to have more than one, you can do it. We will be providing a list of banks that have agreed to offer those accounts, but if you want to have more than one, you can, or if you want to go and find your own one, you're more than welcome to do it. You won't find it to be very easy to get these accounts, but if that's what you want to do. But the trust bank account is going to be from an investment. It's going to be from a private bank, not an investment bank, a private bank, and they're used to working with high net worth individuals. And having worked with high net worth individuals for most of my early career, they want the red carpet.
Yeah,
that's what they want. They want they want to step out the Rolls Royce on the red carpet and walk into the Ritz. That's what they want, and that's what the private banks tend to give them. Because if they don't give them that, the high net worthers will go somewhere else.
Okay. Next question is to do with the 98 series US tax rule. So from an administrative look at IRS rules, US-based individuals appear required to report and pay taxes on a 98 series international grantor trust, with the responsibility moving back to the grantor. How do we clear up this specific reporting friction for US-based members? Another great question.
Sorry, Annie, I've lost the sound again. Some issue here. I'll try and hook up another speaker because this is happening twice. And if you can just pause for a minute, if it's okay, or I'll drop off for a minute. I've got to restart. I can't get my speaker to connect.
That's okay.
Just won't have it at the moment. So,
if you drop off,
I'll have to restart my laptop.
Yep. Okay. Here's me giving Ian instructions, and he can't hear me. So while Ian's doing that, because we can't pause, unfortunately, this is a live stream. So for those of you who are joining us live, thank you for your patience. Let's just have a little chat about Saturday, which is tomorrow. So this is creeping up. We have a webinar tomorrow that you can register for. If you want to register for that webinar, you can go here, roswebinars.is, and you can register for the webinar there. And we're going to be talking about this subject. Why would the US Department of Treasury redirect billions of taxes to ROS members' grantor trusts? So Ian's going to be answering that question. We've already had confirmation of 600 million of taxes on the wages and tax transcript. That's confirmed. That's passed the IRS 810 algorithm. It's gone through the process front to back and has been verified. So if that's the case, then we know that for the 1.5 to 2 billion of recoupments that we originally filed for, if 600 million has been confirmed, there's absolutely no reason why the rest of the recoupments can't go through the same process, which is exactly what is happening. They're going through the exact same filing process as that confirmation of 600 million, and that those two would be redirected to the members' grantor trusts. So a fascinating subject. That's what we're going to be talking about. It looks like Ian's back. So
yeah, back.
Are we back? Are we live, Ian? How are we doing?
Well, there seems to be some gremlins in my computer. So it dropped off twice, and then it just would not connect again. I've got two speakers, and it wouldn't connect to either of them. So yeah, back now.
Not to worry. Okay. So let's go back to category 2. Let's have a little chat about that again. And the question was to do with 98 series US tax rules. And the question is this: from an administrative look at IRS rules, US-based individuals appear required to report and pay taxes on a 98 series international grantor trust, with the responsibility moving back to the grantor. How do we clear up this specific reporting friction for US-based members?
Well, again, I've written a research paper on this recently as well, and I think we're going to do a more in-depth look at this. Yeah, there is legislation about international foreign grantor trusts, grantors who are taxpayers in the United States. That's the SSN taxpayer, having to report income to the United States Tax Authority, the IRS, United States Treasury. So there's two things about this, right? The first thing is, what is income?
Yeah. Again, what is again income?
We've discussed that before.
Talked about that as well.
And you can't actually find any definition of income anywhere, because there is no definition in any tax manual, because of the fact that all signature credit is created ex nihilo from zero. So if there's no value to it, how can there be any income made from it? If everything is a debt, then how can there be an income? See, people think they're rich when actually all they've got is more debt, because it's inverted. The whole thing's inverted. So nobody can actually have an income. That's the truth of it, right? So it's a difficult one to get your head round, but everything on the monopoly boards are negative. It's not, there's no positives on the monopoly board.
No.
So you can't have an income. You can only have more debt. But a lot of people won't want to engage with the IRS and tell, because that would be a difficult fight for them to take. So then you've got to look at, well, what is actually going on here? There are two trusts. There's the tax filing grantor trust, which receives a redirection of taxes. So redirection of taxes could never be an income.
No.
If your trust if you're the grantor of a trust that's receiving a redirection of taxes, how can that redirection of taxes be a taxable income? It's a redirection of tax. It can't.
Yeah.
You can't be taxed on a redirection of tax.
No.
And then the second grantor trust, which is the Asset Fortress grantor trust, there might be a problem here if the member is using an international grantor trust and they've got an SSN number. There could be a problem there, which is why I'm suggesting they use a 508c1a ministry, which is a non-reporting ministry, as their private treasurer. And you and I, Andy, are going to talk more about this in an interview coming up. So there is a solution for it.
Yeah.
There's always a solution. But yeah, that's a very good question. Very, very good question.
It is. Well, yes, we'll be covering that in more detail. So just understand that while we may not have answered it in depth for you today, we will be doing that. And there is a workaround for that. There is a solution to that. So the next category, Ian, is to do with just the evolution of the protocols as well. In particular, what was considered or classed as bank recoupments. So going back 3 years versus signature credit recoupment back to the age of 18. And the first question is, for members currently tracking the 3-year bank statement look back via the Infinite Money Protocol, how do we adjust our files to the newer currency creation protocol that estimates signature credit all the way back to age 18? Do the previous filings move forwards on a separate track, or do they merge together?
Well, you've got 3 years, you see. You've got 3 previous years that you can file tax, the 1099 OID and the 1041. So the grantor trust has got a window of 3 previous tax years. So if you're already doing what was called bank, a lot of people called it bank payment recoupments. I don't think I ever called it that, but it became called, I think it took on that name somewhere along the way, right?
It did.
And it became sort of common knowledge or common practice to use that name.
Yeah.
I always thought it was a bit misleading because you're not actually recouping the bank payment. So it's kind of a bit of a misleading terminology, really. But anyway, a lot of people call it bank payment recoupments. I think in our platform, it might have even been labeled that way at some point. It may even still be labeled that way now. It's technically, it's not correct to call it bank payment recoupments because you're not recouping the bank payments. To call it, tax redirection is the most accurate description of it because that's exactly what it is. Based upon bank payments, based upon mortgages, loans, credit cards, it's always tax redirection. And so if members are doing, they're recouping bank payments or the taxes on bank payments, redirecting from 2022, 23, 24, etc., and the filing is going to be done in 2025. So the tax filing team is choosing 2025 tax year to file the 1041. Then that leaves the 2026 tax year to file for signature credit from age 18. And you can file simultaneously in 2 different tax years. So you can file 25 tax year, you can file 26 tax year, because the IRS system is based on tax years. It's not based on filings, it's based on tax years. And you can even go back to, now you'd have to go back to 23, 24, 25, 26. You basically got the current year and 3 previous years that you can file 1041s from. So there's lots of options here. Now, the research that I've been doing in the last few days has revealed that there's almost certainly going to be a manual review of the tax filings that exceed 2 million per tax year per grantor trust. and I'm going to be doing I think we're going to do an interview on this, Andy, coming up.
Yeah.
To go in more detail. But what a lot of people are not realizing, I think, is that the tax system is a year by year, and you can carry forward what you haven't already recouped in 1 year to another year, to the next year. I think a lot of people are thinking you've only got one chance to do it, but you haven't. You carry it forward, and you can choose different tax years to recoup your signature credit in different tax years from your grant or trust. So I don't see any problem here with people that want to add and where we've been running this system now, from age 18 for a few weeks. A lot of people get very confused about, which years, and I can't remember how much they paid, 20 years ago, and all these things on bank payments, and they might remember their mortgages. Well, I think it's going to become a lot simpler, where if you're limited to $2 million per year, then you work back from that and say, well, what did I do that makes up 2 million? What's my mortgages? Let's do those. What's the highest outflows from the bank accounts? What bank account have I appeared to have paid out from a lot? You don't actually pay out, but it appears that you pay out. Yeah. So let's just pick those, and let's see if we can fill the bucket up of 2 million, and that's going to be a lot easier. And then you've got every year going forward for another 2 million, another 2 million, another 2 million. So as I've said on internally, if our members can't live on $2 million individually, and if they're married, it's $4 million per year, then I think there's definitely a disconnection between what we're doing, freedom, and what people are wanting.
Yeah, agreed. Okay, so next question is to do with commercial bank accounts, businesses, LLCs, that type of thing. So does signature credit tied to historical limited company activities or a US registered LLC also qualify for the lifetime age 18 recoupment protocol? And can these business entities be seamlessly integrated into the Republic of Old Souls? I'm assuming they're potentially thinking about either the Envoy side of things or the 508c1a side of things in terms of what do they do with their LLC moving forwards.
Well, I think it's two questions. The signature credit that's based on the signature. When you set up an LLC, the entity that's actually forming that is the citizen. It is the birth certificate construct that creates an LLC and becomes the director or shareholder of the LLC. So the LLC itself is no different from if you open up a bank account for the citizen, because it's the signature is the living man, woman. It's the living soul's signature that's now being used within the LLC. It's no different, actually, because everything is corporate anyway, right? On the monopoly board, the citizen is a corporation. The LLC is a corporation, but the living soul signature is being used either for what people call a personal bank account or a company bank account. It's the same thing, because it's all about the living soul signature that creates the credit ex nihilo. So that's the first question: is it doesn't matter what the entity is. The signature is always the signature of the living soul. And then the next question is, can you bring an LLC into a ministry? Well, not really bring it into a ministry or to a trust. But what you can do, you could hold it in a trust in theory, why you'd want to. For me, you see that the slavery model is program people to set up companies. And loads of people set companies up thinking that they are somehow beneficial because they've got limited liability. Well, they don't really, because you can still look through a company to the shareholders and the directors.
Yeah.
And I've always had a problem with this, right? Because you set up a company, you go off and start your business, and then something goes wrong, and people think they're shielded by their company because of limited liability. And that's the story that we've been sold by those who sell companies, right?
Yeah.
And sort of common belief that you set a company up, you can walk away from the liabilities of the company, but you can't really. And that's evidenced all over the place for anyone who wants to look at it. In the UK right now, a lot of companies took out bounce back loans, you know, the loans that the government was dishing out through the banks in the alleged pandemic period.
Yeah.
People thought, oh, that's interesting. I'll just get a bounce back loan. And if the government and the bank wants to chase me for the repayment, I'll just close the company down.
Mm-hmm.
To find out that the banks and the government can go after the citizen who was the shareholder or the director of the company. So the corporate veil is pierced quite easily in a company.
Yeah.
In the same way as you form a company and the company gets involved in crime. Well, who's going to go to jail? The company, or is the citizen going to drag the living man, woman into jail? Same thing, right?
Yeah.
But trusts are different. Trusts and ministries are different. There is a separation with a trust and a ministry. And that's why I prefer trusts and ministries. So if you are operating as a ministry and you're taking donations as a ministry, as opposed to taking fees as an LLC, that's got a very different structure to it. A donation, you see, if you're now getting into the realms of ministries and churches, right? Because if a church takes a donation, and I'll be very controversial here, right? Even if Bernie Madoff from the biggest fraud in history, had made a donation to the church could have kept it. So if you know anything about Bernie Madoff, the Madoff 60 billion Ponzi scheme, the biggest Ponzi scheme in history, if he'd made donations to churches, the churches could have kept them, because there is no piercing of the church. It's quite interesting when you start looking into it, the church state thing, right? So if you've got an LLC and you want to collect fees in an LLC and then donate from the LLC to your ministry, you could do that. That's quite a smart way of doing it. Mm-hmm. But making holding an LLC in trust it's not going to. For me, there's no point doing it. You might as well just operate the trust and not have the LLC, in my opinion. So yeah, that's where I am with it.
Okay. So, final question on this section is, why is it? This is a good one. Why is it that when the OID discount is calculated, it is framed at a face value of 0? Considering that investment banks must purchase the underlying securities directly from the clearing banks, can you break down this exact accounting mechanic?
Yeah, it's actually much easier than it appears, right? So creation of the ex nihilo credit is 0. But, and this is the slavery model comes in now, there is interest being paid for the use of the credit.
Yeah.
So if you look at it like a mortgage, you sign for a mortgage, $1 million mortgage, and the bank says, yeah, you'll find the $1 million in your account. And how much interest are they going to charge on that $1 million mortgage for the next 25, 30 years?
Yeah.
Maybe it's 2 million, maybe it's 3 million, depends on the interest rate, right? But it's certainly going to be a lot more than the face value of the instrument, which is 0. So you go 0 at creation, And then you've got all the interest which is being paid for the use of the million. So the debtor, the citizen debtor, is going to pay maybe 2 or 3 million interest. And that interest can be hypothecated because of the usufruct system, meaning that the banks operating as nominees on the monopoly board can use that future value which they've created, because they know that the interest payments are going to come in. In most cases, people don't renege on their mortgages. In most cases, it's a very high percentage of mortgages that get funded all the way through to the end, or they get refinanced. So they're on a bit of a safe bet, because they can say, right, if there's 3 million of future interest to pay, this debtor is going to pay 3 million of future interest. And then they can hypothecate that. They can actually use that and leverage against it. So they can create maybe 10 times, maybe 20 times more than that million, which they are going to sell to the investment banks for a tidy sum up front, which is what the banks are doing every day of the week. Mortgages are the best fruit machine in the world for the banks. So every time they pull the handle, they hit the jackpot.
So
the calculation is you see, securitization, and this is really what investment banks do in a nutshell, is they take the future value of cash flows, and they discount them back to the current value. So if think of it like this, Andy, you and I have just set a business up, right? And it's been running for 3 years, and we make $1 million a year clear. No problem, right? And our business model is impenetrable. It's one of those businesses that just keeps making $1 million a year, right? If you and I decided that we were going to sell our business, and we could prove that $1 million a year is pretty solid, it's not going to disappear because of something's going to change and it's going to disappear. We'd have investors who'd pay us 10 times. I remember 100 times profits valuations in the .com boom. 100 times. Investors were paying 100 times the annual profit of a business to acquire it. Extraordinary. And we don't see it now, but in the .com days, that's how they were valuing businesses. So you see, a securitization is like valuing a business. You've got your cash flows that you can reasonably expect to receive as a bank. You've got the debtor by the balls, because you're gripping them by the balls. They're going to pay the mortgage, otherwise they lose the house. So you've got them by the short and curlies. You've got them. And they're going to carry on paying you. So that's a pretty certain outcome for an investment bank. The what's called delinquency rate for mortgages is quite low, actually. It's a pretty safe bet, because people don't want to lose their house. If they only knew it wasn't their house, maybe they wouldn't care so much. But they believe it's their house and they don't want to lose it. So that's how it works. Future value discounted back. And the future value is very high. Even on bank payments, it's high, because the banks use the signature credit to hypothecate, and then they sell the bank payments as securities to the investment banks. So it's not all about interest. It's maybe I'll write a paper on this, because I think it's quite an interesting subject. So if for those who might want to know how banks value securities, I can write a paper on it.
But I get that. I think in the online space, online businesses are valued at anywhere from 30 to 50 times the annual revenue or the annual profit, let's say. So that makes sense. There's a future value there.
It's just future cash flows. That's all it is what is it worth today? If I can expect to receive it every year going forward, how much is it worth today? How much do I need to pay for it today to receive those future cash flows? That's really all it is.
Okay. All right, let's move on to the next category, which is category 4. And this is to do with jurisdiction and everyday envoy realities. So here's a question. And again, I don't think that people are fully understanding the envoy status. So again, we've got a bit of a gap. If a newly appointed envoy receives a UK Crown Court jury service summons and their administrative request to be excused as a ministerial ambassador for the Republic of Old Souls is rejected, what is the correct step to take to avoid creating joinder with the Crown's jurisdiction?
Yeah, there's quite a few misunderstandings there, I think.
Yeah.
So, yeah, the holding the office or occupying the office of General Executor, so living soul, man, woman, occupying the office of General Executor. General Executor is an office, it's an artificial construct that is sitting above the birth certificate construct, another artificial construct. The jury service is against the birth certificate construct, yeah?
Yeah.
Which we've already established earlier is registered to the state. Don't get a lot of choice on jury service because they already own the birth certificate construct. So again, think of it like sheep in the field. Nobody wants to admit to this or even acknowledge that it's real, but it is real. The citizen is a sheep in the field, and the farmer wants to move the sheep from one side of the field to the other side. They can do it. So jury service isn't going to be stopped by occupying the office of the General Executor over the decedent estate, because you haven't got any standing to do it.
No.
And the only way to avoid jury service is through religious grounds. If the case might be something which offends the religion, it might be something which is, but then there again, you sometimes don't know what the cases are. I've done jury service, and I didn't even know what the case was until I got there, and I had to go many days in a row, because you actually sit, or unless it's changed, I don't think it has. You sit in a waiting room with a load of other potential jurors every morning until you're called into a case. And you might go there for a week and you're not actually called into a case, but you've got to go every morning.
Yeah,
I did it. And when you're called into a case, then you can be rejected because they might not like the look of you, so you can be rejected. So then you have to go back into the waiting room and wait for another case.
Yeah.
So that's what happens with jury service, unless it's changed. That's certainly what happens in England, and not much you can do about it. You can claim that you're not well, but you have to prove it. You can claim hardship, extreme hardship, that if you have to give up your job or your business is suffering, you can stall it and defer it, because you can claim that you've got economic hardship, and turning up for jury service is going to be economically difficult for you. But you can't say that you're an envoy of the Republic of Old Souls, because it ain't going to wash.
No.
Going to work.
Okay, and I think that's where this gap comes from. People are still getting hung up on joinder and thinking that envoy status is a separation of the living from the birth certificate construct, and it's not, is it? We talk about agency being a blessing and a curse, don't we? If you had complete separation, you couldn't do things like recoupment.
The agency's there whether you like it or not.
Yeah.
But what you can do is you can look at individual contracts, for example. So you can look at a contract where the name of the birth certificate was used in a contract, and you could challenge that contract is valid on the grounds that you used the name by mistake. So the birth certificate name, you could say, well, I used that name in error because it's not me. I'm the agent for that construct, but I'm rescinding the agency on that contract, on that individual contract. But you can't say I'm rescinding everything, because you'd have to do it individually, one by one. Because who are you going to say it to? You can make a declaration that you've rescinded your agency on everything you've ever done since the age of 18, but it wouldn't take any effect unless you actually addressed it to the other side of a contract. Then it could take effect. In jury service, let's go a little bit deeper, shall we? Voting is a problem. Most people at some point have voted. Most people at some point have filled in some government form, a census, a government form. Most people have got a driving license. Most people have got a passport. So when you unpack this and say, okay, what have I already done that, and I'm taking privileges off the Monopoly Board. So a driving license will be seen by the controllers as a privilege.
Yeah.
Because you're using, they would say, you're using their roads to travel, and you're using a driving license to do it. Yeah. So the living man, the living soul is using a license which belongs to the crown, the state, because everything belongs to them. And the living man, woman, the living soul is being privileged by using their roads, their license, because the birth certificate construct is theirs. So because those privileges have been enjoyed by the living soul for all these years from the age of 18, you can't really say, you can't have your cake and eat it, basically. You can't say on this matter, I'm gonna exclude myself from the agency when it comes to the state. But on these other matters, like driving and using the passport and using the public services and stuff like that, oh yeah, I'm going to keep all that because I want to keep that. But I'm going to rescind doing the. I'm not going to do the jury service because I don't want to do it. Do you see the problem?
Yeah.
You can't talk from both sides of your mouth at the same time.
No. Okay. Let's move on. Next question. Here we go again. Sorry. Speeding tickets.
Okay.
As a ministerial ambassador and church envoy, what precise administrative action should be taken if the birth certificate construct receives an automated speeding ticket carrying fines and driving record points? Pay it.
Well, yeah. I mean, the easiest thing to do is to fund it and then recoup the discharge of the speeding ticket. That's the easiest thing to do, is a peaceful thing to do. The art of legal warfare comes in if you want to use it. You see, in nearly every case I've ever looked at, in terms of speeding, there's normally a problem somewhere in the camera. These cameras are allegedly they're supposed to be recalibrated every day, right?
Okay.
And invariably they're not.
Okay.
So that's generally the Achilles heel of speeding, because you can ask them to give you the log of how many times it was recalibrated, and then you can challenge it on the basis that the camera wasn't accurate.
Okay.
And then you actually compel them to prove that the camera was accurate, which they ordinarily can't do.
Won't be able
so
to.
If you want to use the art of legal warfare to avoid paying the speeding fines, that's generally the best way of doing it. But there again, do you want to be bogged down with, I mean, if you're going to lose your license and you're up to the top of your points and you're trying to save your license because you want to be able to use the car, then yeah, you probably want to do that. But if it's, again, it's everybody's choice, isn't it? I wouldn't personally waste a lot of my time on a speeding ticket. I'd just discharge it and move on, and then recoup the discharge.
Yeah. Okay. So next one. beyond the IRS, which specific corporate state agencies, such as Birth State Registry, the Treasury, the DMV, which of these must receive our official declaration of life to notify them that the corporate fiction has zero agency over the living man? Again.
Yeah. So, it's an interesting question. A lot of research on this. The state has many tentacles, right? It's a bit like an octopus, but with more legs or more tentacles. Any government office can be served with a declaration, because that's what it is. It's a declaration, and it doesn't go in a database. A lot of people think there's some database somewhere where you serve an envoy notice, and somebody in the civil service is going to say, "Oh, we better update our database." It doesn't work like that. A declaration is a declaration.
Yeah,
it's like if you think of it like this, it's a bit like a spell. You're casting a spell, spelling. Yeah, it's like you're transferring an energy. It's more of a energy transfer. It's a bit like the signature, actually, because that's like a spell as well. The creation of ex nihilo credit, the signature, is like it's like Harry Potter and his wand. You're casting a spell, and that's what a declaration really is. And you're doing it with any government office. Now, the most powerful government office to do it with is the coroner's office, because the coroner, their job is to record births, deaths, and marriages, generally speaking, in most countries. So if you are making a declaration about being alive, then you want to be doing it to the coroner. But any government office will do, really, because it's just a declaration.
Yeah.
And I think a lot of people think that there is some sort of system where you send a bit of paper in, and some civil servant is going to pick that bit of paper up and go, "Oh yeah, we better update our records." It doesn't work like that.
Okay. So category 5, Ian, is talking more about timelines, transcript drawdowns, limits as well to do with the drawdowns. So there's 3 particular questions here. There's one to do with filing. There's one to do with the transcript clearance speed, so timings, and then another to do with this 500,000 envoy operational cap as well, shall we say. So the first question is, why are certain filings, and they're specific about years, so 2023 filings showing individual submissions to the IRS without the simultaneous inclusion of the members' pending 2024 data or older submitted mortgages? Are these separate submissions a tactical decision to bypass processing freezes?
I actually don't know the answer to that, because I don't actually know the situation that we're talking about. So, I mean, generically, there's no tactics going on to avoid any freezes. But if the member is looking in their platform and seeing information in their platform that looks a bit weird, then I think that needs to be looked into. There's no tactics going on. We're not doing tactics. We're just following process. So I'm not aware of any reason why that would be. Maybe there's an administration error in the platform, or maybe it's not being read correctly. I don't really know. I'd need to know the facts about that case. So unfortunately, I can't really answer that one very easily. But there's no tactics going on.
No, because that would mean that signature credit recoupment back to 18 wouldn't work if you had to separate everything out that way, would it?
No, I mean, you pick a tax year, you file. In that tax year, the grantor trust files 1099 OID and then followed up with 1041 in a tax year. And it's using the signature credit references, the CUSIP numbers, and all of the other references that need to be put into the filing for that particular tax year, because you can only file 1041 for one tax year. You can't file across multiple years. No. They're individually. They're like start and end. They're like they're separate. They're just tax years are separate filing constructs, if you like. You can't merge them all together. No. You do it year by year. So again, I can't really answer the question without knowing the details. So
no, that's fine. Okay, next question is, what is the current operational time frame for drawing down funds once an EIN is received and placed onto the platform? Let's cover that one first, because there's a couple of questions here. So that was the first one. What's the current operational time frame for drawing down funds once an EIN is received and placed onto the platform? We've been through this many times.
Yes, well, we've actually done a whole interview on the timeline, and it's on the ROS Media platform, which we're encouraging more of the members to visit that platform.
That would be good.
It would be good if people did that. Generically, 9 months is your window for recoupment of signature credit, subject to every step of the process unfolding without glitch or hindrance or member lethargy or issues with the IRS's system. This is always a difficult question, because it's not an exact science, right? There are time limits for each step. So I can't say in advance, if you start today, in a number of days' time, you're going to have a recoupment in your Asset Fortress protocol. I can't say that, because every case is different. All I can say is that if you say there's a 9-month window, and it could happen in 6 months, or it could happen in 9 months, or it might happen. There are occasions where it could happen after 9 months. There are time frames for each step, but the time frame isn't an exact science. It's up to, say, 3 months for each of the steps of the process. So somebody, one filing might go through in a week, step 1, and 2 weeks, step 2, and 3 months, step 3, and then they get theirs in 4 or 5 months.
Yeah.
And another filing might be every step is 3 months.
Yeah.
We can't control the length of time that the IRS processes each step of the process.
No. Or how many mistakes they might make along the way. So
yeah, I mean, it's just like, if I could create a system where the IRS was compelled to deal with every filing within a certain number of days, it would be amazing, wouldn't it?
Yeah.
We could get the filings through in a matter of weeks. But unfortunately, we can't do that.
No.
So these questions about timelines are, if you were in Germany and you were asking, when's the train going to come, you'd pretty be certain it's going to come on time, yeah? If you were in Switzerland and you're asking about the buses, you'd be quite disappointed if they didn't come on time. Having been to both countries, I know that that's true, right? Yep. And the population gets very upset if the train doesn't come exactly when it's supposed to, and the bus doesn't come exactly when it's supposed to, right? But it's not the same in the IRS. They're not running a train or a bus service. No. They'll do things within their time window, but we can't determine when they're going to do them within that time window.
Or if you live in Devon like we do, and you're wanting a train or a bus, then it arrives when it gets here when it gets here.
Exactly. So somewhere between the Swiss system and the Devon system is the IRS.
Is the IRS system. Yeah, that's a good analogy. Let's leave that one there. Okay. Next question. Are the resubmitted 22 to 24 recoupments fully encompassing members who did not receive an IRS transcript during the initial wave?
I just missed the right at the beginning. Are the 20? Okay.
Are the resubmitted 22 through 24 recoupments fully encompassing members who did not receive an IRS transcript during the initial wave?
Well, that would all be put into the signature credit from age 18 bucket. If you didn't get a wages and tax transcript in 2025, then you're going to be into the signature credit from 18, the 2 million a year limit, etc. So if you haven't had a meeting with our consultant and looked at, is there any more that you could be scooping up into your signature credit from 18 bucket, then I suggest you do that. But if you didn't get a wages and tax transcript, you're in the process with everybody else who didn't get one, and all the new people that have come into the program since 2025.
Yeah. Okay. Now, this 500K cap is the processing cap on worldwide membership, as in the envoys for the Republic of 500,000. Is that strictly tied to the logistical constraints of our internal staffing and security, or is it a structural requirement to keep the social shield completely insulated from public regulatory interference?
What a great question. No, it's all to do with taxes.
Yep, it's not to do with any of those.
It's all to do with taxes. So it's a fantastic question. Although I'm absolutely sure that we will have logistical issues, we will have staff issues, as you always do, when you build and grow something substantial. But that's not the constraint. It's all about taxes. The amount of taxes that the investment banks are paying for the use of our signature credit determines how many envoys, how many members can recoup. So, I've come up with a figure of 500,000 based upon the amount of taxes, the average amount of taxes that the investment banks are paying each year, which is the budget for what we can recoup against. And if we're recouping on average, 1.5 million, 2 million a year per member, which probably would be less than that for some people, then you come up with a number of about 500,000. And that will change, because there may be years where the investment banks don't pay the same as below the average, and then we're going to have to take a haircut on the amount of recoupments that everybody can receive. But we're a long way from that at the moment.
For sure. Well, that's the impetus for people to get on board with the signature recoupment now, isn't it? Because there's at least the opportunity for them to recoup up to that 2 million per annum. By the time we get to 500,000 members, like you said, if the amount that's paid on the modules is not enough, then that figure may well drop. It could drop to 500,000. It could drop to 250K. We don't know, do we? So, okay.
No, I think the reality is that we need a nation that has got sufficient numbers in it. 500,000 is a pretty high number. If we had 50,000, we'd still be very, very, very powerful as a nation, I think. So,
for sure.
It's not about whether our ability to roll out a nation. It's about the tax constraint.
Yeah, understood. Well, that brings us to an end of the questions. So, final call to action, really, from where we are now. What should you do next if you are watching this and maybe you just attended last Saturday's webinar for the very first time, then I would strongly encourage you to attend our webinar tomorrow. And you can register for that at roswebinars.is. So if you go to roswebinars.is, you can register for tomorrow's webinar. You'll be able to do that from your platform as well. You know, freedom doesn't come to people who just sit there waiting for it. It comes from actively moving towards it. So this system, if you think about it and you look at the messaging that we put out here and the end goal of building a nation and the freedom plan that we talk about, you know, this system is going to put everything in its power to test your resolve when it comes to freedom. But we've got protocols that will bypass that friction that you can use peacefully. They only function if you deploy them. So a lot of this is down to you as an individual in terms of taking action. So what could you do right now? If you're an existing member, I say this every single time we do a Q&A, and every single time that we kind of get to those final thoughts, you need to log in to your members area and you need to check that everything is up to date there. Make sure your communication hub messages are read and that there's nothing outstanding there. Make sure that you attend our updates because we do them regularly, and yet we still get the same questions over and over and over again that we've answered multiple times. So go to your platform, look at your communication hub, make sure that everything's up to date there. We only move at the speed of the most prepared members because that's the speed that is the fair speed to move out. We can't wait for people who are not prepared to take action and look at their platform. Now, if you are brand new and you are just joining us here and you are seeking freedom and you're aligned with what we're talking about here, and you've maybe just attended 1 or 2 webinars, then join us tomorrow. Okay, we have another webinar tomorrow, Saturday, 23rd, 10 a.m. UK time. And the subject that Ian's going to be breaking down there is why would the US Department of Treasury redirect billions of taxes to ROS members' grantor trusts? Why would they do that? So if you want to know the answer to that, join us tomorrow. Like I said, you can register from the website here, roswebinars.is. You can register from your platform as well. We'd love to see you there, 10 a.m. sharp. Now, that's all I've got to say on that side of things, Ian. Any final thoughts from yourself before we let everybody go?
Yeah, I mean, my thoughts are always that education and knowledge is the key to freedom. And a lot of people are very distracted by nonsense out there. I see it all the time. They don't understand the nature of the game that we're all playing, the Monopoly board game. They don't get it. There's a lot of confusion. A lot of people are trying to do things that have been tried many, many times before and don't work, but it doesn't stop new people trying them. And you know, there are things that do work and there are things that don't. So my final thoughts are: if you're going to go down the pathway of changing your life for the better, do things that work. Do things that have got a track record that actually logically fit together and make sense. And stop trying all these things that have no track record, even though they might sound very attractive. And there's plenty of them out there. I see them all the time. And, you know, the focus, in my opinion, we should all be focusing on things that give us joy, that give us, give us a better experience of playing this game, rather than going down all these pathways, which probably are going to bring a lot of trouble back to you. We've spent years putting our protocols together, having tried nearly everything that others are trying, and learning the hard way of what works and what doesn't work. We're pretty well researched on what works with track record. So you can waste a lot of time going down other pathways, or you can come to my webinars, because my webinars are packed full of things that actually work. So that's my final thoughts.
Okay. Well, like I said, we'd love to see you there tomorrow, 10 a.m. sharp UK time. Registration link is on the website and on the members area as well. And one more thing is, if we are going to grow this nation, then we need your help too. We need you to pass this message out to other people, you know. So if you are an advocate here at the Republic of Old Souls, then you can use your unique advocate link to invite other people to the webinars and invite other people into the Private Members Association. So rather than just register for yourself and think that you're taken care of, maybe think about taking care of other people who, you know, if there are people within your immediate circle who align with what you're talking about, and they don't really like the thought of surviving in a debt-based control system, but they'd rather live more freely and pursue things that they enjoy, then this is right up their street. So we'd love for you to invite those people too. So for now, have a great day. Thank you for joining us. If you're joining us on the socials, and that's all the questions that we had from registration that we've got answered. Obviously, I'm sure we'll have more questions tomorrow from the webinar. So I'll be sifting through those, and Ian and I will be answering those for you on next week's Q&A session. But for now, have a great day.
Bye for now.